Now, by now, we've all heard that the United States Supreme Court heard a legal challenge to President Trump's executive order, which seeks to end birthright citizenship for illegal aliens and to end the practice of birth tourism. Now, an anonymous petitioner with the pseudonym of Barbara, who was represented by the ACLU, filed a lawsuit to declare the executive order illegal on constitutional and statutory grounds. Now, the oral argument took place at the Supreme Court of the United States this week. So I've reviewed the legal authorities and I've come to a decision. Now, the Supreme Court can agree with me or not. I'll just remind everyone watching this video that law is not a popularity contest, okay? And the job of the judiciary isn't to make policy. The job is not to make policy, okay? That's for the U.S. Congress, and just because the Congress can't muster a bare majority in both houses of Congress to enact a statute to enshrine the principle of jus soli, now that's Latin for birthright citizenship, does not open the door for a single district judge in the middle district of nowhere to step in and try to make policy for the entire United States of America and call it law, okay? But that's what's happened in this case. Trump v. Barbara is the name of the case at the U.S. Supreme Court. Okay, President Trump's executive order ending the practice of birthright citizenship passes constitutional muster, in my view. Okay, there it is. According to my review of the legal authorities, the principle of birthright citizenship is not a constitutional requirement. Now, it's clear from the history of the 14th Amendment, which was ratified in 1868, that it wasn't intended to grant citizenship to children born here to parents who were just sojourning and not domiciled in the United States. Now, the 14th Amendment was ratified just after the Civil War to ensure that newly freed African Americans would be granted full citizenship rights. Now, that's why the Citizenship Clause was ratified, Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, the text goes on to say, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, that's a reference to the southern states, formerly slave states. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. A constitutional amendment ratified by the states to protect newly freed African Americans. Now, the southern states, which had seceded from the Union, were forced to ratify the 14th Amendment as a condition of regaining representation in the U.S. Congress. So that's the political bargain that was made to get the 14th Amendment ratified. So that's the historical context. But as I mentioned, in modern times, the amendment has become divorced from the historical context. For instance, people nowadays come to the United States just to have children on this soil. They come illegally on their own voluntarily. They're not brought here in chains. They're not brought here on a slave ship, not forced to work the plantations, endure unspeakable brutality, and be accorded the legal status of property. Now, with that being said, modern-day slavery does exist. Some people are trafficked here. They did not come here willingly and might qualify under the original historical context after being freed from their bondage. And then there's the practice of birth tourism. Now, elite members of Chinese society and Russian society, for example, pay tens of thousands of dollars to come here to give birth on this soil because it's been the policy of the United States for decades to grant citizenship by birth regardless of the status or intent of the parents, namely their lack of domicile in the U.S. Now, the northern states, after the Civil War, and all of the abolitionists in the antebellum era, including President Lincoln, would turn over in their graves to see how their efforts are being abused centuries later. So, how did we get here? Now, it was a gradual process. Americans are very compassionate, so one individual after another, one group after another, went to the courts to seek a ruling that says the 14th Amendment applies to them. Now, in 1940 and again in 1952, the U.S. Congress enacted Title 8 of the United States Code, Section 1401, subsection A. This is part of the Immigration and Nationality Act, and it codifies the Citizenship Clause. A person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States. Now, the ACLU's Supreme Court brief says that this section of the INA codifies the principle of birthright citizenship because allegedly that's what the U.S. Congress believed the Citizenship Clause meant in 1940 and 1952. However, now if we look at the text of the Citizenship Clause, there is ambiguity there. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Now, what does subject to the jurisdiction thereof mean? Now, we can look behind the text to the legislative history because our understanding of the words will be very different from their understanding in 1868 when the 14th Amendment was ratified. A century and a half of time in and of itself gives rise to ambiguity, and so we can look behind the text in keeping with the rule of statutory construction that says we don't look behind the text unless it's ambiguous on its face. And it is, if for no other reason than it was drafted a century and a half ago. So what does subject to the jurisdiction thereof mean? Again, we have to look behind the text. That gives us the answer. Now, at the time the 14th Amendment was drafted and ratified, the understanding was that the text did not encompass illegal aliens or birth tourists, the full gamut of economic classes coming here to give birth on U.S. soil because they were not subject to the full political jurisdiction of the United States. Now, the parents were subject to the rule of a foreign sovereign, and that is what their children inherited. Now, President Trump's executive order to avoid chaos in implementation says that the executive order applies prospectively, that is, going forward, not to be given retroactive effect. Okay, now what about the statutory grounds? Now, if an executive order violates a statute of the United States, the executive order is illegal. Now, provisions of the INA, which is a statute of the United States, enacted in 1940 and 1952, contain the same verbiage as the Citizenship Clause. The government's Supreme Court brief says the INA quotes directly from the Citizenship Clause, so it should have the same meaning in the INA. Now, as I mentioned, the ACLU representing petitioner Barbara says the INA should reflect the understanding of Congress at the time it enacted the provisions in 1940 and 1952, but the ACLU's brief doesn't go on to discuss what the congressional intent was in 1940 and 1952. Okay, not with any depth, although the ACLU should have done copious amounts of research, given that its best argument is the statutory ground, not the constitutional ground. Now, if I'm the Supreme Court, I would reverse and send the case back to the lower courts for full briefing on the statutory grounds, because the ACLU, representing petitioner Barbara, in my view, has lost on the constitutional argument. The ACLU's entire case is premised on a Supreme Court case from 1898, United States versus Wong Kim Ark, which says that a child born in the U.S. to parents of Chinese descent during the time of the Chinese Exclusion Acts, who were domiciled in the U.S. but not citizens at the time of the birth, their child is a U.S. citizen at birth. Now, his parents ran a business in San Francisco when he was born, so they were domiciled but not citizens because the Chinese Exclusion Act prohibited the Chinese from becoming citizens of the United States. Now, the basis of the Chinese Exclusion Acts was racism, so the Supreme Court held that Wong Kim Ark was covered under the 14th Amendment's Citizenship Clause. Now, the ACLU is relying on that case, the Wong Kim Ark case, to argue birthright citizenship for illegal aliens in modern times when the issue isn't racial discrimination or any type of discrimination. It's just their illegal entry or illegal intent and lack of candor during entry. Now, if I'm the Supreme Court, I would rule against the petitioner Barbara on the Wong Kim Ark case. Barbara is not similarly situated to Wong Kim Ark. There's no exclusion act that discriminates against Barbara on an impermissible basis, such as race, under the equal protection laws. Now, if I'm the Supreme Court, I would send the case back to the lower court for full briefing on the statutory argument. What was the intent of Congress in enacting Title 8 U.S. Code Section 1401, subsection A in 1940 and 1952? Now, that's going to be the ACLU's best argument, in my view. Now, just to conclude, a big shout out and thanks to AG Pam Bondi. As of yesterday, she returned to the private sector. She did a fabulous job as AG, and I don't know why she's no longer the AG. She attended the Trump v. Barbara oral argument at the Supreme Court with President Trump this week, and if the mainstream media has it right, she was informed she would no longer be AG just before the oral argument. And given how the oral argument went and the quality of the government's legal arguments, her role in the Trump v. Barbara case could not have been the reason for her departure, in my view. Now, in any event, good luck to acting AG Todd Blanche. Now, what a tremendous presence he is on the legal stage. Will he be nominated for the top job? Now, that's up to the president. His former AG, Bill Barr, is kind of looming in the background, so he might get the nomination. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.